This is Investigations 101. This is something that our stewards had asked for more information on. I want to start out by clarifying you, as stewards, are not representing your coworkers in investigations. In other unions, that is how the structure works. But here at OCEA, you have a team of professional labor staff, myself, Donica, Elise, Sam, Ollie, all the others that are on the court team. And we're the ones who go in and represent employees when they're facing some potential discipline. So I want to start out with that. So everything that's in here, this is for your knowledge to help support your coworkers. You are not expected to attend one of these meetings. And if a coworker asks you to, you should tell them to contact OCEA staff. First thing on the agenda we're going to talk about is what are investigations. Then we're going to go a little bit into your Weingarten rights. We're going to look after that about the outcomes of investigations and what comes after that. That is a whole training in itself, so we're just going to briefly touch on it, but maybe next time we can go over if someone does receive discipline, what happens after that. And then we'll touch on what is your steward role. How can you help your coworkers when they are in an investigation or get a memo or something like that. So, first off, what is an investigation? So, an investigation, a workplace investigation, is a formal, structured process conducted by an employer to gather facts about an alleged incident, complaint, or policy violation that occurred in the workplace. So, essentially, the court becomes aware that there's a potential policy violation or potential misconduct. Maybe another employee reports something, a supervisor, a manager, something gets reported, and an investigation is looking into that report to see what happened. Was there a violation of court policy or some misconduct? The core purpose of of an investigation is to objectively determine what happened, whether a policy was violated, and what, if any, corrective action is warranted. Something to note, it is a fact-finding process. It is not a disciplinary one. So just because someone is getting called into an investigation does not mean that they are going to get disciplined. I will say more times than not, if they are getting called in, there's probably something there that they are investigating, but it's not a guarantee that they'll get in trouble. I've been in plenty of investigations where the questions were answered and it turns out there was no policy violation, there was no misconduct. It was just a misunderstanding that needed to get resolved. So if an employee gets a memo and they're scared, I'm going to get fired, I'm going to get this, just let them know the investigation is just to find facts. Anything that comes after that will come after that. So I keep mentioning this memo, right? So what happens when an employee is notified that they'll be investigated is that they'll receive a memo. This is quoted directly from a memo that an employee received from the court. So it'll come in the form of a memo to the employee. It'll be delivered by hand, typically by the supervisor, and it'll say something pretty much exactly like this. So this is to advise you that an investigatory meeting, which you are required to attend, has been scheduled for, and that it'll have a time and a date and then the location of the meeting. This meeting is regarding concerns about blank, and this will be a very general statement. So it might be regarding concerns about the court's code of conduct policy, about a potential violation of the EEO policy. It might mention a more specific policy. So, for example, violation of the personal court case disclosure policy, right? It'll say it very broadly, but it won't say the exact incident that is being investigated. And that's very intentional. They want to protect the integrity of the investigation, so they'll just let you know generally what they're looking into. This investigation may result in formal disciplinary action up to and including discharge from court employment. That is standard. That's on all notices of investigation. So if one of your coworkers gets that and thinks that means that they're going to be fired, that's not what that means. That's a standard statement on everything. Could they be terminated from employment? Yes, if that's an outcome from the investigation and discipline, but that particular statement is on every memo. So just let them know that's a very standard sentence on there. You have right to representation. You may choose to represent yourself, or you may be accompanied by a representative from the Orange County Employees Association. They have to contact us to get representation. We do not contact them. Most of the time, we don't know who is being investigated. The court may coordinate with a rep just to make sure that schedules align in case an employee reaches out, but they 99.999% of the time do not tell us that employee's name. So they have to contact us. So that's very important. This is a confidential personnel matter. To that end, and to avoid interfering with this investigation, you should refrain from discussing this matter with anyone other than your union representative. So, if you have an employee who's going around telling everyone that they're in an investigation or they think that this is what it's about, please remind them, keep that confidential. We don't want them to have any new discipline on them because they went around sharing confidential information. So it is extremely important. They can ask you as a steward questions and you can guide them to us, but really the only people they should be talking about the investigation with is their assigned OCEA staff. So who attends an investigation? So there are a few different people who can attend, right? So first off, obviously the employee. The employee is the one in the investigation. If they choose to have one of us, a union representative, OCA staff will be there as well. I put optional because the employee can go in and represent themselves. Obviously, we don't really recommend that. We would prefer if employees bring us in. We know what to expect in investigations. We know how to help clarify questions and answers and those sort of things, and really can be there to support the employee during an investigation. And so if they do want us there, we will be there. And then from the department side, so there will be most of the time it's the supervisor, the direct supervisor, but it might be the manager over the program or the department that they work in as well, just depending on what is being investigated. And then an HR representative. Typically, the supervisor is the one asking the majority of the questions in the court. For some areas, that's different. Like at the county, the HR representative is the one who asks all the questions. For the court, it will be the supervisor or the manager who is asking about the incident. So sometimes people want to know who's going to be asking me those questions. That's who it's going to be. Actually, I lied. I do want to stop for questions because I don't want to get too far. Are there any questions so far?
So this is a situation that I had. I had on my team somebody who actually are there investigations where those memos are not handed out? Can they start informally?
Yeah, so the employer can start informally asking questions. We have a long-standing relationship with the court, and CB can chime in here at any time too if he wants. Typically, if they are investigating something that can lead to discipline, they're going to provide a memo because it keeps things clean. It makes sure that everything is followed, protocol, policies, that's all followed. That way, if there is discipline that comes out of it, on the court side, they're doing everything that they need to do, right? Because if they don't, that gives us ammunition to come in and fight it. However, if they're looking at something informally, they might call someone in to ask, hey, do you know about this incident? Or do you know what's going on? Why did you do this? In that case, it falls on the employee, and we'll get into it in a second, to ask for union representation. And how you do that is you ask the question, could this meeting lead to discipline? And the person on the other side, if they answer anything other than no, then the employee can ask, then can I please stop this meeting and get my union representative here with me? If the employer says no, the employee should just document that. If it really feels like it keeps going and it's no, these questions sound like they can lead to discipline, the employee can ask again. But typically, if it is going to lead to formal discipline, HR will be involved. I don't know if Adam, I see your hand up.
Yeah, I just was wondering, as far as the court is concerned, does the language of the memo vary if they're, like, for example, calling in somebody as a witness versus the person who's being investigated? Like, how does that memo look? Do we know?
Annika, do you know I haven't had any witnesses?
Not specifically, that's a great question though, but not specifically with the courts. But what I can say is when they are at county level, when someone is called in as a witness, they'll typically receive the same memo. But however, HR may be a little bit more flexible in terms of what their role will be in there, because being a witness does not always require a rep in the room, as the individual being called in as a witness is not the person that is being investigated, or they're not the individual in question. If they do receive a notice, I would assume that it would be just like any other notice that anyone would receive. You probably would get a heads up though and just be notified that it is a witness investigation, which does not require a representative, and also means that the employee necessarily wouldn't be entitled to that representation because the employee is not being investigated themselves.
Did that answer your question, Eric?
Yeah.
Okay, cool. And I just want to add to a lot of investigations that we take are often around big events, right? This one thing happened and now you're getting investigated for it. But there are investigations around a lot of little smaller events, right? So work performance is something that's a common one, is someone is making mistakes in their job pretty regularly, right? In that case, you would have had conversations with your supervisor or with your manager about those little mistakes, right? They would have been calling you into the office, hey, what happened here? Hey, what happened there? Here, what happened there? So it's not uncommon to have those conversations already, but it generally, for things that are like bigger or could lead to some formal discipline, HR will be involved. Does that help?
Yeah. Absolutely.
Okay, cool. All right. So, what happens during an investigation? So, I'm going to go through just what that process looks like, kind of front to end. They're all usually the same. So, if your coworker's really freaking out and I don't know what to do, I don't know what to expect, this is what's going to happen during an investigation. So, first off, before the investigation even starts, the member and the union rep, we will have met ahead of time, right? They'll have hopefully let us know what they think that this investigation is about. We would have talked about it. We'll meet a couple of minutes before the meeting and answer any of their questions, things like that. So they should have had enough prep time with us by the time we get into this formal meeting. When the formal meeting starts, so it'll start out, the supervisor will have a paper in front of them and they'll be reading from a script, right? And so this is a very standard thing that they'll say is they'll talk about the purpose of this meeting, to find facts about a certain incident. They'll let the employee know that this meeting could potentially lead to discipline up to and including discharge from employment. Then they will give the employee a directive to answer honestly and completely, and we will come back to this, but that directive is very important because if an employee does not answer honestly and lies in an investigation, they will they could, but they will be further disciplined for any sort of dishonesty that happens in the investigation. And I will say, especially at the court, often the discipline for being dishonest is much higher than the discipline for whatever incident occurred. That is something that they take very seriously. Then the supervisor will move on to some foundational questions. This is just to set the stage. So they'll ask things like, what's your current job title? Who's your current supervisor? Usually the person sitting across from them asking the question. How long have you worked with the court? What are some of your typical job duties? What's your work schedule? Just things like that to establish a foundation. Then the questioner, the supervisor, will move into maybe some specific policies or procedures. So these will be related to what the investigation is about, right? And so if an employee is being investigated for violating the court's code of conduct, they'll probably get the code of conduct handed to them, and the supervisor will ask, are you familiar with this? What's your understanding of this policy? They might hand over some transcripts, like Eureka transcripts, or this is when you signed, this was when you were last trained. What they're trying to do is they're just trying to establish that you know the policy, you've been trained on the policy, you're familiar with the policy, you understand it, right? That will give you a big clue onto what you're being investigated on if you don't know already what policy that they bring out. Then they'll move into a specific incident. So they might establish a little bit more foundation, right? Were you working on this day? Are you expected to do this job duty? That sort of thing. But then they'll start asking about the incident in question. This is typically where the employee, if they don't already know what this investigation is about, will go, oh, I know what this is about. And in that case, us as the union rep will call a caucus. HR and the supervisor will leave and we'll discuss, okay, what incident, what happened, what's going on. Then HR will come back into the room, supervisor will come back into the room and continue questions. They might bring out evidence. So if there's any emails related to the incident, like any work product, like minute, anything like that, if there's video evidence, they'll bring that in, but the employee will view all the evidence and have a chance to respond to it. So for example, they might bring out an email and say, did you send this email to X person, and ask you questions. Why did you say this? Why did you say that? That sort of thing. And that'll be the majority of the investigation. Again, that's the part that's crucial that the employee answered truthfully, because it's never good to lie, but especially because most of the time they do have all of that evidence ready. And so if they ask you, did you send this email to this person? And the employee says no, I can almost guarantee you the next thing they pull out of their folder will be the email that was sent to that employee. So it's always best for employees to be completely truthful in these meetings. Before any of the investigation ends, there will always be a chance for employee comments at the end. So the supervisor or the HR representative will ask, is there anything you want to add? Any comments, any context, anything like that? And this is where as a staff member, the union rep, I'll pregame with the employee ahead of time if there's something that needs to be clarified. If the employee really did make a mistake, talking about that, saying, I completely understand, it won't happen again. I understand how serious this is. Anything that needs to be said, that's their chance. And it will always end with a chance to do that. So if the employee really wants to make sure something gets heard, that's the place to do it. Anything to add, Donica, CB? No?
So in my experience, this last section is important because the labor rep will be taking notes throughout the process, and if there's anything that needs to be added, I've even taken the lead, and I'm going to ask questions now. And me and the member, we will orchestrate what those questions are and what the answers are so that we get it on the record. The so there's that. And then secondly, I've always told our members that your job is to tell the truth, even if it doesn't put you in the best light. Your job's to tell the truth. My job is to protect your rights. And they're just very different, right? And we don't allow the employer to run roughshod over our members. And while it's their meeting, this is a bilateral process, and it is the labor rep's job to help orchestrate and facilitate to a degree how this is going to go. So don't think that just because someone is in an investigation that it's just the Wild West and the employer gets to do anything that they want. Our job is to protect our members' rights. That's all.
Yeah.
I
Perfect.
actually Sorry, I want to echo a little bit of what CB said, because one of the questions that I've gotten in the past has been, what exactly is your role if I'm being the one that's asked the questions and I'm the one that has to respond? And ultimately, it's just to ensure that your rights are not being violated as an employee. So even if our participation may seem minimal, is because us as the reps, we at that time are identifying that the questions that are being asked are in no way out of line with the type of questioning that they could do. But of course, just keep in mind that we're paying attention at all times. And sometimes what happens is the question, if it doesn't make sense for the employee, kind of to what CB would just said, we will then step in and re-clarify or re-ask the question in a different way. And so that's when you'll really see our involvement. But if the questions are being asked, there's really no concerns on how they're asking the questions, they're not really hounding the employee or being aggressive towards the employee, our participation may be a little bit more minimal because we'll just be taking the notes. But just rest assured that we are trained to listen and keep an ear out for anything that might be a flag for us to step in. That's always just something that I like to share with the members, because sometimes they have questions of, you were just taking notes, and it's, no, we're doing a lot more than that, right? But it just seems like that. So just know that we're definitely keeping your best interests in mind when we are in those rooms. But there's only so much that we can operate within as your reps, and one of them is just making sure that the questions that they're asking you make sense for the process.
Yeah, and I think there's at least one supervisor on here. So I know you guys might also be the ones asking the questions in the court, right? I've definitely been in an investigation where the supervisor across from us was a steward. And so I just want to emphasize that part. We're in there to protect the employees' rights. We're not in there to get them out of trouble. We're not in there to yell at the people across the table. We're not in there to do any of that stuff. We're there to make sure that the process happens and that we protect the employees' rights. Anything that we can do to lessen discipline or explain context or what was going on in an employee's life, like while the incident was happening or anything like that, we'll do our best to do that. But ultimately, we're there to protect the process and make sure that everyone's given their sort of due process. Any questions from stewards? Perfect. Okay. So, like I said multiple times that we've all said, an employee's responsibility, the only responsibility an employee has during the investigation is to answer the questions and tell the truth. An employee will be very nervous before an investigation, right? You don't know what they're going to ask about. Oftentimes, I get the question, I'm sure Donica gets the question, is what can I do to prepare? There's nothing to prepare. All you're going to do is answer some questions about what happened and tell the truth. If there's a specific incident that you're like, I know they're going to ask me about this, and you have supporting evidence like emails or pictures or whatever, feel free to bring that. That's absolutely, you can prepare in that way and bring that stuff. But the majority of the time, the only employee responsibility is just answer the questions and tell the truth. If there's any follow-up that's needed, you have an email that wasn't in the investigation that could help your case, we can follow up with that after. We just really want to know, what are they asking about? So a little bit on what Donica and CB kind of touched on. So what is our OCA staff union reps role in an investigation? So first, like I mentioned, we're going to be able to consult privately with the employee before, as soon as they get their notice. During, we can call caucuses, have the HR person and the supervisor step out of the room. And then after the investigation, we'll have a chance to talk with the employee, just us. We'll be able to request clarification on vague or confusing questions. Sometimes when a question is being asked by the supervisor HR, it's not clear, or it's a little bit misleading or directing or lacks foundation, something like that. Those are all things that we're listening for to make sure that the employee is asked a fair question so that they can give a fair, truthful response. Object to intimidating or improper questioning tactics. If the we'll say HR, right? If the HR representative gets a little bit too rowdy in the investigation, gets a little bit aggressive, we're going to step in at that point, right? Because this is a fact-finding process. There doesn't need to be that type of aggression or asking the same question over and over, badgering, that sort of thing. If they have a question, they can ask it. The employee can, and that's what this process is meant to be, not anything intimidating for the employee. Help the employee correct a misunderstood answer. I know I do this in a lot of my investigations. Employees really stress during this, so sometimes their answers aren't as clear as they could be, or maybe an employee provided context to me in a caucus that didn't provide when they answered their question. So we as the rep might step in and say, hey, you told me XYZ caucus. Do you want to tell them that if you think that it might help your case? Or if answer was just confusing, we might say, hey, can I help clarify for them? Or hey, can you clarify that a little bit more that they understand? Making sure that any answers that are given aren't misunderstood or misconstrued. But let's see, we provide information or context that may help the account. Like I said, if they shared something to us during caucus that maybe they didn't get a chance to say, we'll encourage the employee to share that information. Or CB said, we'll ask the questions ourselves at the end of the investigation to make sure that it's on the record. Let's see, we'll help remind the employee of their rights and then help the employee understand what's next. We do these all the time, and typically by the end of an investigation, we can pretty well see where this is headed and a conversation with the employee. Hey, I don't going to be much that comes out of this, or oh, you're looking at suspension, or hey, this was very serious. Prepare for the worst, sort of thing. This is my slide on investigations, and then I'll take questions. Some rare situations that come up that are related to, and I want you guys to know about these in case your coworkers ask about them. So the first thing is a temporary work reassignment, right? So an employee one day gets a notice that temporarily they're reassigned from Lamoureux Justice Center to Central Justice Center. It's not for a business need. It's not for any purpose of a project or anything like that. It's to protect the integrity of investigation, right? Typically, they'll be told that's what it's for, that there's something being investigated. Work reassignments aren't super common in the court, but it does happen occasionally, very rarely. But basically, it's because the employer is investigating something and they've determined that they can't leave the employee in that department, in that work site, whatever it may be, while they're conducting their investigation. More common, but still very rare, is administrative leave. And this is for the integrity of an investigation. The employer believes the employee can't be in the workplace whatsoever, right? And so they pull them out of work. You're at home. You're expected to be on call from 8 to 5. Can't go on any vacations, can't have a few beers, can't do any of that. You've got to be ready to go, ready to answer the phone within minutes if they call you. But you are being paid during that time while they complete their investigation. This can happen before an investigatory meeting, so you might be placed on admin leave before you even get a notice of a meeting for an investigation, or you might answer questions in an investigation and they might find out information that then leads them to put you on admin leave while they finish their investigation. These are very serious when they do happen. Again, it's not a guaranteed conclusion that you're going to get discipline, but typically when you are put on admin leave or when you are reassigned, they are investigating something very serious, so it should be treated as such. The court's very fast in their investigations. I keep using the county as reference. We do a lot of them in the county as well. The county takes months to do their investigation. Someone can be on admin leave for months. The court is very fast, typically from the time someone receives a memo to the time they know their intended discipline. We're talking a week or two. The court moves very fast, so if someone's placed on admin leave, most likely it's not for long. Any questions from stewards, comments from OCEA staff?
Alisha, I'm not sure that you've got a slide for this. If you do, then just forget what I'm going to mention. But can you talk a little bit about property rights and notices of intent in the state of California to either demote, suspend, or discharge?
So I don't have anything specifically on that, but I have a little bit of it later, so I'll touch on it when I get to that.
Okay.
But that's the part, what CV said, which I'm going to go over, is going to be a training in itself because it's such a large topic. So, yes. All right, moving on then. So I mentioned it earlier, but Weingarten rights, this is something that you should be extremely familiar with as stewards. If you've ever seen an OCA bulletin board, we have a little Know Your Rights flyer. This is what's outlined on it. On all of our business cards, on the back of it are your Weingarten rights. So what are they? Your Weingarten rights are the legal rights of a unionized employee to have a union representative present during any employer interview or meeting that the employee reasonably believes could result in disciplinary action. So that's where it gets a little bit tricky, but like I said, we have a pretty long-standing relationship with the court, and they typically provide memos, and so you'll know exactly what meetings you need a rep at. However, I'm gonna call on Donica and CB for these examples. Okay, so we've already established if you get a memo for an investigation, you are entitled for a rep. Yes? Yes. What if you are called in to talk about your work performance?
Yeah, so that's a question we get often. And the short answer is you can't have a rep in there. So, of course, you could always ask if the meeting could lead to discipline. At that point, if the supervisor says yes, then of course you have the right to enact your Weingarten rights, state that you want a rep present, and then the meeting should not occur, right? But if the supervisor's response is no, and they're saying it's just a check-in, but the meeting still feels maybe like it's leading towards discipline, even if the conversation leads to an investigation, what was likely asked in that meeting or in that initial meeting with your supervisor would then be addressed again officially through the investigatory process. And it has happened where an employee maybe goes in for a regular check-in, maybe they say something that the supervisor was unaware, and as a result of that, that leads to the investigatory process that could lead to discipline. But that official meeting request from your supervisor with the employee, that it would not be something that you would likely need a rep for, especially because, to Alicia's point, we have such a great relationship with the court that they would always notify or likely notify the employee that there is something that could lead to discipline. So that should already be taken care of. But the same way that employees have their rights, managers or the department have theirs as well, and that includes meeting with their staff as they see fit. Sorry, CB, I think you had something.
No, I was just going to underscore that Weingarten was never intended to be an obstacle between a direct report and their supervisor or manager. It was simply, and I appreciate Alisha pointing this out, in the first sentence, who reasonably believes? The employee. And so if the employee reasonably believes that the dynamic, the questioning could, not will, but could result in discipline, then you can invoke your Weingarten rights. But it was never intended to be this hard obstacle between you and your boss to say that I can't be questioned without a rep. That's not the intent behind Weingarten.
So some other instances where an employee would not be entitled to their Weingarten rights, if they are receiving their performance review, even if it's a substandard performance review, if they're just receiving it, they're not entitled to their Weingarten rights. Same thing with discipline, right? Let's say someone did have an investigatory meeting, or they're just receiving a written reprimand or a notice of intent, anything like that. They are not entitled to a union rep at that time if the employer's not asking them questions that could lead to discipline, right? They already have the discipline. Same thing with if an employee just doesn't get along with their supervisor or their manager and they want to have a one-on-one, right? That in of itself, you are not entitled to your Weingarten rights unless your supervisor or your manager starts asking you questions about things that could lead to discipline. In which case, moving on to the next slide, very important to have that question in your arsenal, in your coworkers' arsenals. Could this lead to discipline, right? Could my answers lead to discipline? And if the answer is not no, ask for a union rep because the right has to be triggered by the employee. The employer is not required to notify the employee of their rights. Like you saw earlier for the court in their memos that they give people, they will let the employee know they have a right to representation, but they don't have to. As we said earlier, the union rep's role is to assist and counsel the employee, not to obstruct, using CB's direct words, not to take over interviews, not to do any of that, but just to make sure that rights are followed. And then again, they apply to investigatory interviews, not routine work conversations or performance reviews if they don't lead to discipline. Okay, I know we're running up on time, so I'm going to power through the next slides and then we'll do questions at the end. I only have a few left. So investigation outcomes and next steps. When will an employee know if there's discipline? There's no notice of discipline at the end of the meeting. Very rare circumstances. They might be noticed that they're now on admin leave or something. Very rare. Usually it takes a few days to a few weeks to know the outcome. Like I said, the court is very fast. And so I usually have within the next day or two, the employee knows the outcome of the investigation. And how will they be notified? Their supervisor or manager will typically hand them the discipline. It'll be handled in person to them. It might be emailed to them as well, but typically it's just handed in person. When an employee gets that, they need to notify us right away because we are not notified when an employee gets disciplined. We might occasionally get a heads up from the HR rep that they're wrapping up the investigation, but they will not tell us, hey, investigation concluded and they got this, right? That doesn't happen. So the employee needs to notify us right away because if there's any timelines involved, we need to make sure that we hit those deadlines. At the end, an employee can receive formal or informal discipline. Informal discipline doesn't have an appeal process, cannot be grieved. Things like this are counseling memos or your supervisor just talking to you and saying, hey, don't do that again. Or if you get a memo of expectations, those things don't have an appeal process. Those go in a supervisor's drop file. So they may be mentioned in your next performance eval, but they don't have a formal appeal process. The things that do have a formal appeal process that are considered formal discipline at the Superior Court are a written reprimand, any sort of suspension or discharge termination from employment. Each of these things has a different deadline on when you can appeal them. So it's super, super important. I cannot stress enough. The minute the employee gets that decision, they need to contact us because we also need enough time to look in the MOU, confirm which path it falls under, confirm the timeline, who we're responding to, that sort of thing. What CB had said earlier about notices of intent and property rights in California. So when you are a California public employee, you have property rights to your job. So they cannot just fire you. They cannot just suspend you. They have to notice you that they intend to suspend you or fire you, right? And so what that does is it triggers what's called your Skelly rights, Skelly, and that's from a court case. So that's someone's name. And what do you want to interrupt or do you want me to go first and then you can come in after? This
You
is me.
power through.
Okay, this was me concerned that I said something wrong. I was like, oh no, what did I mess up? So it triggers your Skelly rights. So what that is that they've notified you that they intend to do this, they intend to suspend you, or they intend to terminate you. And what it does is you are now allowed a chance to respond to a hearing officer to make the case of why that discipline should not happen. So let's say they're trying to suspend you for 5 days. You have a chance to go in to an impartial hearing officer and talk to them about, hey, I shouldn't be suspended at all. Or, hey, 5 days is a lot. I've never had discipline before. This wasn't that serious. 1 day is more appropriate. Or if they're trying to discharge you, saying, hey, I shouldn't be discharged at all. Or this is too serious of a discipline. I've learned my lesson. I won't do it again. It didn't have any consequences. A suspension is more appropriate or a written reprimand is more appropriate. That's the time to go in and try to get it removed or lowered. CB?
Yeah, I just wanted to, it's not that you said anything wrong. I'm just going to add to it. And that's the part of once you pass your new hire probation, successful completion of your new hire probation then establishes your property rights in your job.
Yes. And we'll do a full training on the types of discipline and stuff. It's not anything you need to know the specifics of. We don't even have the specifics memorized. If someone brings me a written reprimand, what I'm doing is I'm in the MOU looking at the section that says written reprimand. How many days do I have? What step of the grievance process does it get filed at? Who do I file it with? Even if I think I know the information off the top of my head, I'm sure Donica can agree, we're in that MOU because each MOU is different and each type of discipline is different. And you're not expected to be an expert. Even the experts go back and refer to the MOU. So, last thing, and then I'll open it up to questions. Where do you all fit in this? And I know I've gone through some of it as we've been going through this training, but first and foremost, if an employee gets a memo of that they're being investigated, please tell them to call us as soon as possible. We get calls all the time from people, hey, I got this memo a week ago and my investigation's today. Can you be there? No, we can't be there. We have meetings scheduled. They need to call us ahead of time. I'm just kidding. We would make it work. But they need to call us ahead of time as soon as they get that memo. That way we can get them assigned to someone because there's different reps on the court. I think we have 5 different reps to the court. They can be assigned to someone specific. That way we can start talking with them and working with them to see, hey, what's going on? And we can get a little bit familiar with each other before the investigation. 2, remind them that this is a fact-finding meeting. It doesn't automatically mean that there will be discipline, but it should be taken very seriously because it could. If it does lead to discipline, we can help with the appeal process, but again, we don't get notified of the outcome of the investigation, so they need to contact us as soon as possible. Because once they miss those deadlines, they miss those deadlines. It is not something that's flexible. And then finally, advise your coworker that the most important thing they can do is tell the truth. They will 100% each and every time get in even more trouble if they are dishonest or if they withhold information. If they're concerned, they can talk to their rep about it and we can talk through. Ultimately, it's their choice how they answer questions in meetings. They're adults, but our advice will always be to tell the truth.